Thank you for joining us. Welcome to another Talks with Tutors events. Just so you're all aware, this session is being recorded. When it gets edited, your names will be removed, but when you ask questions, if you want to unmute, do just be aware that your name might appear in the recording, which is fine with us as long as it's okay with you. Welcome to today's event. We're really excited to be able to have a chat with a professor of politics here at Oxford, Professor Paul Billingham, who's going to give you a talk today for about 40 minutes. At the end of that, there'll be a chance for questions, and that might be about what you're about to hear in the presentation, or more broadly about studying politics or PPE at Oxford, or just generally Oxford altogether. So I really hope you enjoy, and I will hand over to Paul.
Great, thanks a lot, Amy, and hello everyone, thanks for coming to this. So you should now be able to see my screen. Amy, is that okay?
Yeah, we can see that, thank you.
Great. So as Amy said, I'm Paul, and I'm a tutor in politics here at Magdalen. I should just say that there were 3 little children downstairs, so I'm sorry if there's some noise that distracts, but hopefully there won't be. So I'm a political theorist, and that means that I think about questions regarding how we ought to organise our social and political lives. So things like what kinds of laws we should have, what it means to achieve justice or equality or freedom, how we ought to respond to pluralism within society, such as religious or cultural pluralism. And today, I want us to think about the issue of religious exemptions, which is an issue that touches on many of those topics that I've just mentioned. And the basic question I want to think about is this: should laws or rules ever include exemptions granted to people on the basis of their religious beliefs? So within liberal democracies, we generally believe that everyone should live under the same laws, because that's a matter of fairness. It seems unfair if some people are allowed to do things that others aren't, or if some are granted freedoms that others lack. We don't generally think that people should get special treatment. And we also apply that in other contexts, like employment. We think fairness demands employees within companies should work broadly under the same rules. But religious individuals have often asked for their religious beliefs and their religious practices to be given special accommodations. For example, through them being given special exemptions from otherwise applicable rules and laws. And so this question is about whether those kinds of exemptions can ever be justified. So here's an outline of what I'm going to talk about. So I'm going to start by explaining just 3 real-life claims for these kinds of exemptions that have been made in the UK. And I'm then going to explain some arguments that have been made against granting such exemptions, and then some arguments that have been made in favour of granting them. As will become clear, I think that the arguments for exemptions are stronger, and I think we should endorse a policy or an approach that's sometimes called reasonable accommodation. So this is the idea that both the state and also employers should seek to make reasonable accommodations to enable religious individuals to practice their religions, and that can include giving exemptions where appropriate. And those kinds of exemptions have in fact been granted from various laws in both the UK and the EU, and also elsewhere, such as in the USA. So the 4th thing I'll do is just say a little bit about the law. But there's still a question here, which is, even if you think that exemptions in general can be justified, there's a question of when they should be given or when they shouldn't be given. What tests should be used to decide when to grant them? And so if there's time, I don't know if there will be, but if there is, the 5th thing I wanted to do is give you a bit of an answer to that question, a framework that I would use to assess exemption claims. So we'll see whether we get there. But let's start with the 3 examples. So the first involves Sikhs and motorcycle helmets. So under UK law, motorcyclists are required to wear helmets while they ride their motorcycles. However, the law includes a specific exemption for Sikhs. Many Sikh men believe that they're obligated to wear their turban at all times. This is a sign of their religious devotion. It represents honor, self-respect, courage, spirituality, and piety. And it's not possible to wear both the motorcycle helmet and a turban. And so UK law, specifically the Motorcycle Crash Helmets Religious Exemption Act 1976, permits Sikhs to ride motorcycles without wearing a helmet if they're wearing their turban instead. So if I rode a motorcycle without wearing a helmet, I'd be committing an offence. I'd be liable to be stopped by the police and to be issued with a fine. But that's not the case for turban wearing Sikhs. So the question is that kind of religious exemption justified? Here's the second example. So this involves a woman called Nancy Awada, and she's a Christian who worked for British Airways as a member of their check-in staff. And she wanted to wear a small cross over her uniform as a sign of her commitment to her faith. And this contravened British Airways uniform code. That code required that employees wore no visible jewellery because that was part of the British Airways brand image. Now, British Airways did allow employees to request exemptions for mandatory religious clothing, but not for any other kinds of jewellery. And Awada was sent home without pay for refusing to remove this cross. She lost out on 4.5 months' pay. She lodged a complaint against British Airways in court, arguing that they'd breached her right to manifest her religion. So Awada didn't see wearing this cross as obligatory. She didn't think that her Christian faith required her to wear it, but she thought it was an important way for her to express that faith and that she should be accommodated in doing so. And this is an example of a broader range of cases that involve religious individuals wanting to wear religious clothing or jewelry at work. So there are many cases involving Muslims who want to wear a headscarf, and such cases have ended up in the courts in Europe. So some companies and institutions have rules against any expression of political, religious, or philosophical belief by their employees when at work, and have thus barred Muslim women from wearing a headscarf. And that's led to legal cases contesting this. There have also been some cases in the UK involving school children who want to wear religious dress that falls foul of their school's uniform rules. So again, should Awada's request for an exemption have been granted? And what about this more broader set of cases involving religious clothing? Should these exceptions be made? Here's our third case. So this involves a man called Iftikhar Ahmed, and he was a Muslim school teacher in London. And he wanted to attend Friday prayers, which occur during Friday lunchtime, and are an important part of the Muslim faith. So he requested permission to have a longer lunch break on Fridays so that he could go and attend Friday prayers. And then he said he would make up the time that was lost from the early afternoon in another point in the week. So he still worked full-time hours, but he wanted a rearrangement of his timetable. So this is another case where employers are being asked to accommodate religious practices, but here it's in relation to the way the working week is organised. So there have been other such cases, for example, involving Jews not wanting to work on Saturdays. And there are also some other related cases here, for example, when exams clash with religious festivals and students want to be able to attend the festival, so want to take the exam on a different day. So again, should these kinds of requests be granted? So I'm actually going to stop speaking in a second for just 90 seconds to give you a chance to think about this. So as I've already said, in the next part of this talk, I'm going to run through various arguments both against and for exemptions. But before I do that, before I turn to the arguments that political theorists have made, I want to give you a chance to think about what arguments you would make, what you think about this topic. So here are the pictures of the three cases you can see. And I'm just going to pause for 90 seconds and give you a chance to think about them. What do you think about these cases? Okay, so now that you've had a bit of a chance to think about it, I'll tell you some more about what political theorists have said. And you might well find that a lot of the things I've said are things that you've already thought about now. So as I said, I'll start with some arguments against exemptions. And the first of these is the argument that exemptions often aren't really required in order to protect religious freedom. So you might think that the obvious reason that people want exemptions is precisely in the service of their exercise of religious freedom. But some have argued that even if religious freedom is important, that doesn't mean exemptions are required, because laws and rules usually don't directly conflict with religious practices. So the law that requires people to wear motorcycle helmets doesn't restrict Sikhs' freedom of religion, because they can simply choose not to ride motorcycles. It's not the case their religion requires them to ride motorcycles, so they can simply choose not to ride, and that way there isn't a conflict. And similarly, Aweda and Ahmed didn't have to work in their particular jobs. If the rules of their employers conflicted with their religious practices, then they could have just sought alternative employment. So if the law directly said that people can't go to Friday prayers or can't wear turbans, then things would be different. But those kinds of very direct conflicts are actually fairly rare. Most of the cases where people ask for exemptions involve these indirect conflicts, where the individual could refrain from engaging in the relevant practices like riding motorcycles, and thereby continue to abide by their religious beliefs. And further, this argument goes, people should bear the costs of their own beliefs. If my religious beliefs means that I'm unable to engage in certain practices, then that's a cost that I should bear. Those costs shouldn't be imposed on other people. So, for example, Ahmed shouldn't impose the cost on his colleagues who have to cover his teaching on the early afternoon on Friday so that he can go and practice his religion. People should bear the costs of their own religious beliefs and practices. So that's the first argument. Religious freedom doesn't require exemptions, and indeed people should bear the costs of their own beliefs. Here's a second argument. Exemptions violate equality of opportunity because they mean that those with certain beliefs are permitted to do things that people who don't have those beliefs aren't permitted to do. So Sikhs are granted a freedom that I am not in UK law, the freedom to ride motorcycles without wearing a helmet. And that violates equality of opportunity or equal freedom. It gives some opportunities that others lack. Whereas a law without exemptions doesn't do that. If the law just required everyone to wear a helmet when riding motorcycles, everyone would have an equal opportunity to ride. Everyone's permitted to do so as long as they wear a helmet, and everyone's barred from riding if they're unwilling to wear a helmet. So opportunities there are equalized. And the same argument applies to other cases. If we give Aweda an exemption, then she's allowed to wear her cross necklace at work, while her colleagues at British Airways who aren't religious aren't allowed to wear their jewelry to work. So that's the second argument. It's a violation of equality of opportunity. The third argument is that exemptions treat religious preferences differently to other kinds of preferences. So I might really want to ride a motorcycle without wearing a helmet. I love the experience of feeling the wind blowing through my hair, but I wouldn't be permitted to ride without a helmet despite that. If the police stopped me and I said, look, I'm not wearing a helmet because all the joy for me in riding motorcycles comes from the wind blowing through my hair, and so that's my motivation for riding, they would fine me anyway. I can't just refuse to follow laws because I want to do things some other way. And yet, for Sikhs, their religious preference, their desire not to wear a helmet because of their religious beliefs is accommodated by the law. But why is that? Why should the Sikhs' religious preferences lead to an exemption, whereas my preference doesn't? So the argument here is that exemptions are unfair because they treat these different kinds of preferences differently. And so you might say, if there's a strong argument for having a law, that argument applies to everyone and no one should be granted an exemption. If there's good reason for motorcyclists to be required to wear helmets, that applies to Sikhs as much as it does to anyone else. And no one should be able to get an exemption from that. If there's a strong case for the law not applying to people, if perhaps wearing a turban is really more important than wearing a helmet, that just shows the law shouldn't apply to anyone. It just shows that that law isn't that important. So we should either have a law or we should not have that law. We shouldn't have this situation of laws or rules plus exemptions, because that system, law or no law, is the way to guarantee equality opportunity, treat different people's preferences the same, and it doesn't violate religious freedom. So equality, fairness, and freedom all point to denying religious exemptions. So that's the case against exemptions, or one version of that case. And I think these are forceful arguments, but I also think that they're wrong. So I now want to turn to some arguments for exemptions and show why I think that those arguments against are in fact flawed. And again, I'm going to run through three arguments here. And these three arguments in many ways provide direct responses to the three arguments I've made against exemptions. So the first argument in favour of exemptions is that religious freedom can be burdened by these indirect conflicts. So the first thing to note is that there are cases where the law does directly conflict with the religious practices. So there are cases where the law simply bars things that religious individuals want to do. So for example, there was a recent legal case where a man wanted his body to be cremated in accordance with his Hindu beliefs. And that involved being cremated on an open-air funeral pyre, which isn't permitted in UK law. And so there was just a direct conflict between this religious practice and UK law. And the other classic case of direct conflict is where there are pacifists who are called up for military service and don't want to serve precisely because of their pacifism. So the first thing to say here is that there are direct conflicts, and the case for exemptions is particularly strong in those cases. But the other important thing here is that even when conflicts are apparently indirect, like in the three cases that I've been using as my examples, that can still create severe burdens on religious freedom. So it's true that Ahmed could respond to his situation by leaving his job. He's not legally required to be a teacher. So there's a sense in which the law doesn't directly require him to against his religious beliefs. But the rules of his school, his employer, do directly conflict with his religious practice. If he's to keep his job, then he must act against his religious convictions. There's a direct conflict at that level. And that creates a severe burden overall, because leaving your job is not a light cost to bear. Making it the case that people can only comply with their own religious beliefs if they seek alternative employment is itself a burden on religious freedom. Now, part of the argument against exemptions was that people should bear the cost of their own beliefs. And there's something importantly true about that, but the idea is more complicated than it first seems. So think about the Sikh's requirement to wear a turban. That doesn't directly impose the cost of not being able to ride motorcycles. The belief isn't I shouldn't ride motorcycles, the belief is I should wear a turban. Not being able to ride motorcycles isn't a cost inherent to that belief. It's a cost that arises because of the way that religious requirement interacts with the law. So in an important sense, it's actually the law that requires motorcycle helmets that creates this cost. So people should bear the cost of their beliefs, but that's not the same as people bearing all of the costs that are created by the interaction of their beliefs and the law, because those costs are imposed as much by society as they are by the individual's religion. And so that's precisely why there can be a case for easing those costs in the case of a conflict. So that's the first argument. Religious freedom can be burdened in these cases, and the idea of bearing the costs of your own beliefs can't be used to dismiss them. The second, oh, there were some more things on the PowerPoint here that I forgot about, sorry. That's a summary of the things I just said. So the second argument here is that equality of opportunity favours exemptions, contrary to what the argument against exemptions claimed. So that argument was that exemptions violate equality of opportunity, but that's based on too simplistic a view of what equality of opportunity involves. And that's because if you take a case like the case of Ahmed, he lacked the opportunity to combine full-time work with his religious practices. And that wasn't true of his Jewish and Christian colleagues. So from that point of view, it's the failure to accommodate Ahmed that violates equal opportunities. And similarly, I can ride a motorcycle without violating any religious or conscientious commitment, whereas Sikhs couldn't ride a motorcycle without violating a religious commitment unless they're granted an exemption from the motorcycle helmet. So the thought here is that what we should be concerned with are equal opportunities to engage in important activities without violating any religious or conscientious commitment. And this is important because rules are often based on the views and the culture and the practices of the majority. And that might well be justified, but it can create special burdens on minorities. So why is it that Ahmed faced this situation where attending his religious service, the Friday prayers, conflicted with the requirements of his working week? Well, it's because the British working week was designed with Judeo-Christian beliefs in mind. That's why Saturday and Sunday are our days off. If Ahmed lived in the Middle East, he just wouldn't have had this problem because the standard days off in Middle Eastern countries are either Friday and Saturday or Friday and Sunday. So in those countries, it would be Christians or Jews who have this kind of problem. So the point here is that a rule that looks entirely neutral, you have to turn up for work Monday to Friday, 9 till 5, that rule isn't necessarily as neutral as it first appears, because it's a rule that's created with certain beliefs and practices in mind, and that they can then create special burdens on people who have different beliefs and different practices. And in that sense, such rules don't create equal opportunities. As I said, Ahmed and I don't have equal opportunities to combine full-time work with practicing our religious beliefs. And that's why there's a case for exemptions in the name of equality of opportunity itself. Now, the third argument here is that religious beliefs and practices are special. So the previous two arguments, I think, actually implicitly rely on this third claim, because you might reply to both of the previous arguments by saying, well, people still have equal opportunities because opportunities should just be defined in objective terms, not relative to people's beliefs. So consider me choosing not to ride a motorcycle in light of the requirement to wear a helmet because I want to feel the wind rushing through my hair. We wouldn't say that I lack the opportunity to ride a motorcycle. We would say that I have that opportunity, but because of my particular preferences, I'm choosing not to take that opportunity up. So why are we saying something different about Sikhs? And the answer to that must be that there's something special about Sikhs' religious convictions that require them to wear the turban as compared to my desire to feel the wind in my hair. And the important difference is that the law impacts on Sikhs' conscientious commitments, their religious and moral integrity. And freedom to live consistently with one's religious convictions matters more than freedom to live consistently with other desires and preferences. We should respect and protect religious integrity wherever we can. And that's why equality of opportunity should be conceived of in a way that takes religion into account. And that's why that sometimes means granting exemptions. So this kind of thought has been expressed in various different ways, which you can see on the PowerPoint. So different theorists have talked about ideals of personal integrity, the freedom to live according to your own core identity constituting commitments, the importance of the freedom to pursue one's conception of what has value in life, the importance of conscience, the faculty by which we search for meaning in life. And all of these are really ways of cashing out the claim that there is something special about religious beliefs that merits special treatment, such that Sikhs should be granted the exemption from the motorcycle helmet law, whereas I should not. Now, it's very important to note here that some non-religious beliefs share the special character of religious beliefs. They too can be a matter of integrity or conscientious commitment or the search for meaning. So the claim here that religious beliefs are special is not a claim that religion is uniquely special, or that the only kinds of beliefs that are special in the relevant way must be religious. It might well be that the arguments for exemptions apply to non-religious conscientious commitments. And many of these arguments also apply to things like cultural practices as opposed to religious ones. But for the sake of this talk, I'm just going to keep focusing on religion. But it's important to bear in mind that I wouldn't say that it is only religion that should be given this kind of accommodation. There's also a second way that religious beliefs and religion can be special, and that's that religion often has special social salience. In many societies, religion is a key marker of identity, and it often affects the distribution of resources and opportunities in society. And that's relevant to some kinds of exemption cases, especially when people make claims about non-discrimination. So, for example, a company's rules on dress might disproportionately affect religious individuals, as in the case of, say, rules that say that employers aren't allowed to wear any headwear, which will disproportionately affect Muslim women who want to wear headscarves. And this gives us reason, the fact that religion can have this social salience and be disproportionately burdened gives us reason to recognize religion as a protected characteristic. So to pay attention to the way that neutral rules, like bans on headwear, can be recognized as indirectly discriminatory against religion because of the particular burdens that they can impose. Okay, so I've now run through 6 arguments for and against exemptions, 3 on each side, which you can see summarized on this slide. So on this slide, the 3 arguments in favor at the top and the 3 arguments against are below. And as is probably clear, or as I've stated explicitly indeed, I think that the arguments for exemptions are stronger. And I think that means there are cases where those exemptions should be given. Now, that obviously doesn't mean that every time anyone asks for some kind of exemption, it should be granted, or that religious people can just ignore the law and do whatever they want in the name of their religion. But it means that we should have this policy of reasonable accommodation, seeking to accommodate religious beliefs and practices when we can reasonably do so in order to protect religious freedom and equality of opportunity. So I wonder if you agree. I'm going to take another 60-second break where you can just think about these various arguments I've run through and consider which of them you find most persuasive. So again, I'm just going to pause to give you a chance to reflect on this, and then we'll come back and I'll have a little bit more to say. Okay, so the fourth thing that I said I was going to do was just say a little bit about the law. And as I've already made clear through various examples, there have been many claims for religious exemptions in the UK and in Europe, as well as in other countries. So here's just a list of some of the kinds of issues that have arisen. Most of these I've mentioned already, and there were also plenty of others, but this is just a non-exhaustive list of some of the kind of examples. And as you might expect, some of the claims for exemptions that have been considered by legislatures and courts have been successful and others have been unsuccessful. So I've already mentioned that UK law gives an exemption for Sikhs to wear motorcycle helmets, to not wear motorcycle helmets, sorry. Similarly, in the UK, we have exemptions that permit butchers to produce kosher and halal meat, which involves slaughtering animals in accordance with Jewish and Muslim religious requirements. But claims for exemptions are often denied. So both Nancy Awada and Iftikhar Ahmed lost their cases in the UK courts. When claims for exemptions are made, they're often made under Article 9 of the European Convention of Human Rights, which is the article that protects the right to freedom of thought, conscience, and religion. And this article is just reproduced, copy and pasted in the UK's own Human Rights Act. So this is the article here, and as you can see from the phrase I've highlighted, it protects the freedom to manifest religion, not merely freedom of belief. So it recognizes that religion isn't just about having particular beliefs, it's about exercising, engaging in certain practices. And it says that the freedom to manifest belief, the freedom to engage in those practices, should be protected. And it's notable too that it protects the freedom to manifest religion, not merely in worship and teaching, so not merely in religious services, but also in practice and observance. So in broader sets of practices that are seen as part of the religion, such as wearing particular items of clothing. So when Awada, for example, made her claim for an exemption, this was the law that she appealed to. And as I already mentioned, she lost her case in the UK courts at several levels of court. But she actually took her case all the way up to the European Court of Human Rights, where she could directly appeal to the European Convention. And she won at that level. So the European Court of Human Rights ruled that Britain had failed to adequately protect Awada's freedom of religion by ruling against her in the various cases in the UK courts. So, as you might remember, Awada wanted to wear her cross necklace that was banned by British Airways uniform requirements. And the European Court ruled that wearing that cross was part of Awada manifesting her religion. So it came under this article. And they ruled that the reasons that British Airways had given for not letting her do so, so the reason was that staff not wearing any jewelry was part of their brand image. The court says that reason wasn't strong enough to justify restricting Awada's religious observance. So for that reason, the court ruled in her favour. But it's important to see that this Article 9 of the European Convention on Human Rights also offers fairly broad categories of reasons that freedom of religion can be limited. So this is in paragraph 2 of the article. So it says that this freedom can be limited by any laws that are deemed necessary in a democratic society in the interests of public safety, protecting public order, health, or morals, or for protecting other people's rights and freedoms. So if any of those conditions apply, then a claim for an exemption can be denied. You can say, well, the law isn't violating this person's freedom of religion in a way that requires change or exemption. And that means that claims under this article often lose. So the European Court considered 3 cases alongside Awada's. So they considered 4 British cases at once, and Awada won, but the other 3 claimants all lost. And there have been various other recent cases where restrictions on religious practice have been ruled by a European court to meet the conditions listed in the second paragraph here, such that exemption claims have been denied. Now, I think that in at least some of those cases, the wrong decision was made, because I think the court has made it too easy for the conditions in this second paragraph to be satisfied. But that leads to a question, which is how should we decide whether to grant an exemption? We don't want it to be too easy. So we don't want people to just say, I'm violating any law I want in the name of my religion. And many people who oppose exemptions worry that there would be a slippery slope where loads of claims are made, many of them spurious, in a way that ultimately undermines the rule of law. But on the other hand, we don't want to just deny all exemptions, or at least those of us who are persuaded by the argument for reasonable accommodation don't want to. So it shouldn't be too easy for the state to just say, oh no, this law is required by public safety or by morals, such that the exemption is denied. So we need some way to weigh the strength of the claim for an exemption against the strength of the reasons for denying that exemption. And so the final thing in this talk is that I want to very quickly sketch a test that I think can be used to do this. So this is a framework for assessing exemption claims. And this is something that I've written up into a kind of a long paper, but I'm going to now try and do in kind of 3 minutes. So this is going to be quick and sketchy, but it gives a bit of an indication of how I think we should view this. So the framework has 3 parts. So the first 2, A and B, are at weighing how strong the claim is for the exemption. So the first, A, says this: how central is the burdened religious practice to the individual's religion? Is it something that's seen as obligatory, that they have to do in order to follow their religion? Or is it just something that they kind of desire to do on religious grounds? Or another way to ask the question, how central is this practice to the person's religious life? Is it a core aspect of their religion, or is it periphery? So these questions are seeking to understand what you might call the religious cost the individual will bear if they don't engage in the relevant practice. So, for example, Sikh men believe they're required to wear their turban. It's an obligatory part of their religious observance. They believe they violate a religious obligation if they don't wear it. So if we stop Sikh men from wearing the turban, then the religious cost is failing to follow this obligation. Whereas in the case of a wader, she wanted to wear her cross to express her faith, but she didn't see it as obligatory or essential to her religious practice. It was a nice thing to do for her, religiously motivated, but it wasn't central. So on this first criteria, the Sikh's claim is stronger than a wader's claim. Second, B, asks what cost the individual would bear if she obeys an exemptionless law or rule while finding some way to still engage in the religious practice. So earlier I noted that even indirect conflicts between law and religion can create burdens because the person faces a cost if they abide by that law consistent with their religion. And that's the cost that's trying to be measured here. So if we have a motorcycle law without an exemption, then Sikhs couldn't both obey that law and abide by their religion. Sorry, they could both obey that law and abide by their religion if they just never rode motorcycles. So that's the cost they would bear, the cost of never riding motorcycles. For a wader, the only way she could wear her cross, consistent with the rules of British Airways, would have been to change jobs, because she couldn't wear it in the job she was in, so she would have had to change jobs. So that's the cost she would bear. So this cost is what you might call a secular cost. It's a cost in terms of lost opportunities to engage in activities that other people are able to engage in. So question A is about the religious cost the individual bears if the law or rule makes them not engage in their religious practice, while question B is about the secular cost they bear if they find a way to continue that practice consistent with the law or rule. So these questions capture the kind of choice of costs the individual faces if there's no exemption. So it captures, therefore, the strength of the reasons that we have to grant that exemption. And then we have to ask question C, what are the costs to the rest of society in granting an exemption? What is the state's or the employer's or society's interest in having this law or rule applied to everyone without exception? So this captures the reasons we have not to give an exemption. And then what we have to do is weigh the costs we identify under C against the costs in A and B. How do we do that? Well, my view is that exemption should be granted if there's a reasonably weighty claim on dimension A. So there's a genuine religious practice that is being burdened by this rule or law. Secondly, the claim has to be strong on either A or B. So the individual has to face a high cost on either of these two dimensions in order to have a strong claim for an exemption. So claims are strong on A when the practice is obligatory, like in the case, or very central to the life of the religious believer, like in the case of the Sikh's claim. Claims are strong on B when the opportunity the person loses are very important ones, such as the case of a waiter, where the opportunity is the loss of the ability to carry on in her job. And then finally, exemptions will be granted when the cost in dimension C is relatively low, when the cost to society from granting that exemption is low enough that those strong costs on either A or B outweigh it. Okay, that was way too quick and probably hard to follow, but it's just a quick summary of how my proposed framework works. There's loads more I could say about it, but I shouldn't. One thing that I will note to finish is this, which is none of this is an exact science. We can't precisely measure any of these costs. We can't apply some mathematical formula. We can't get out a ruler or some weighing scales. Instead, we have to use the exercise of judgment. Politics and political theory always involves the exercise of judgment. So the aim of this framework isn't to make it easy to work out when to grant exemptions. It's to show what are the relevant questions we should be asking, what are the relevant considerations we should take into account if we're faced with a claim for religious exemption. But that still will require a careful exercise of judgment, a careful sensitivity to the various aspects of the case in order to make a decision, in order to come to a conclusion. And this element of reasoned judgment is part of why I think political theory is fun and fascinating, enjoyable, because it precisely requires us to carefully think through the different dimensions of these questions and work out which side we think has the stronger case. So I'm going to finish there. There's more I could say, but I'm not going to because I've already slightly over time. So I'll stop there, and I'm looking forward to chatting more in answer to your questions. Amy.
Thank you so much, Paul. That was absolutely brilliant. Really, really interesting. If anybody has any questions, you are welcome to use the raise hand function. You can unmute yourselves and ask, or you can put them in the chat. Anything at all, maybe you've got thoughts on what you've just heard or some further questions you'd like to ask. Maybe you're curious more broadly about sort of studying politics. Anything at all. There are no silly questions. We'd love to have whatever you would like to know the answer to. I'll give you a couple of seconds to think. Yes, is that Yasir? Do you want to unmute and ask a question?
Yes, hi. I just had a question, and for many secular countries, such as like France, who are legislating, well, what they call like indirect laws, such as the recent banning on meat which isn't electrically stunned. Well, they claim that these are like indirect laws, but in fact they affect directly Muslims and Jews who can't eat kosher and halal meat anymore. So does this count as like institutionalized racism, legislating these laws?
Great question, thank you.
Yeah, good. So the first thing to say is I do think it can be right to see the conflict that's created there as, in a sense, indirect, because there is a way that Muslims and Jews can continue to abide by their religious requirements and obey those laws, which is not to eat meat. However, I agree with you that that is a burden, and indeed it is a restriction on the practice they would need to engage in order to eat meat, i.e. halal, going through the relevant ways of killing animals for the halal and kosher requirements. And I agree with, I think, what you're implying, which is that there's a problem with those laws that don't have exemptions. So I think that the arguments I've made in this talk would apply, and I would say that there should be exemptions, and I would apply the framework that I've given to show why that's the case. The specific question you asked was whether that was a case of institutionalized racism. And that's a much harder question, I think, because it involves deciding whether you think that the denial of exemptions in that kind of case could only be motivated by or be kind of informed by racist motivations and kind of ongoing racist assumptions. And I guess I don't think I'm in a position to make a strong claim on that. So I think there were political theorists who genuinely think that we shouldn't have religious exemptions for reasons that aren't racist reasons and that can be well justified in the ways I suggest in this talk, even though I think they're wrong. I think their arguments overall should be rejected. So I don't think that everyone who would support those laws that you mentioned is racist. Whether the specific, institutions which have in fact enacted those laws in specific countries are demonstrating institutional racism, I wouldn't want to kind of pass a verdict on that without kind of knowing more about the specific cases. I would say it's possible, but I wouldn't want to kind of nail my colours to that mast either way. I hope that makes sense. And you're welcome to come back on that if you want to.
Brilliant, thank you. Did you want to say anything? Yes, no worries. If not, did that answer your question?
No, that was fine. Thank you. Cheers. Yeah.
Brilliant. Yeah, that was a great question. Thank you. Did anyone else want to unmute or anything in the chat? It's always great when someone unmutes. We love that. Yes, we've got another hand. Cameron, go ahead.
Hi. I was just wondering, in your framework for assessing exemption claims, it appeared fairly subjective, in my opinion, down to how weighty a claim is, for example. And I was just wondering, is there anything written in legislation or any sort of, I guess, scale, if you wanted to downplay the severity of it, to sort of make sure that the judgment of how strong a claim is on a certain area is less subjective and more objective in order to make a fair judgment? If that makes sense.
Yeah, that's a great question. So what's written in legislation, I mean, at the EU level is this article, which doesn't really give us much specific guidance of the kind that we'd need to make these kinds of judgments. There's a test in the USA, which is in in the act called the Religious Freedom Restoration Act, which applies to federal law in the USA, which says that if a religious practice is substantially burdened by a law and there is no compelling state interest in that law, then there should be an exemption. But I don't think that's particularly objective either, because we still need to know what counts as a substantial burden. And I don't think there is a way to answer that question that isn't going to come down to a level of subjective judgment. And that's what courts and legislators do. They engage in subjective judgment about these cases. That doesn't mean that they can't be right or wrong. It just means that it is an exercise of, as I said at the end of my talk, reasoned judgment. There's a further element, I think, to what you asked, which is, so A and B of my proposed framework, which weigh the strength of the claim. B, I don't think, is subjective. So the way I understand the cost there is to do with the objective interests that the person that's at stake, like having to change your job or not riding motorcycle helmets. So I'm understanding that objectively. But A is subjective. So how central the burdened religious practice is to someone's faith is a subjective question. And I think it depends on the answer to that question with respect to them and their faith. So some people think we should take a more objective approach to that question. So you might say something like, well, you have to look at religious texts, look at like the canons of the religion or religious law, and that gives you an objective standard. So you could, look at the Bible or the Quran and say, is this written as a rule? And if so, then that shows as a substantial burden. And if not, then there is no substantial burden. So some people want to take a more objectivist approach to that question. But I think that that's a mistake for various reasons, but partly because it assumes a level of it assumes that all the things that are important to a religion are kind of written, codified in that sense. And it assumes that each religious person or each member of religion simply has exactly the same set of beliefs that can just be directly read off a text. And that's just not the case. So there are other reasons as well, but I think that we should take a more subjective approach to weighing the burden. And I think that's kind of unavoidable if we want to do it well, even though, as I guess you implied, it comes with costs, which is that it makes it harder to do it, and it might lead to worries about perhaps spurious claims, because people can just say, I have this belief. And one final thought on that is that I think we need to engage in tests, what are known as tests of sincerity. So to check that the person really does have this belief. And I think there are ways that you can do that, and indeed courts do that. So they see whether people have lived out this belief, whether it is something that genuinely is reflected in their lives. And if it's not, then that's a good reason to think there's not a bona fide claim. So one quick example of that is there was a case in the UK of a Muslim chef who took his employer to court because they made him cook non-halal meat, and specifically I think sausages and bacon, and he said that was against his religious beliefs, and then a witness testified that they regularly saw him eating bacon butters, and so evidently it wasn't in fact, and so his case was rejected on grounds of sincerity. So I think we should engage in that kind of test, but it still is, I think, ultimately about the individual's own religious beliefs, and therefore will always have that subjective element. That was quite a long answer to your question, but hopefully that made some sense. Again, feel free to come back.
Yeah. Thank you.
That.
It was very poorly worded questions, though.
No, not at all.
No, these are great questions. Thank you so much. Does anyone else have any other questions? Again, you're welcome to unmute or put it in the chat and I can read it out. Can I ask, Paul, is this something that students might touch on in sort of their first year of studying politics?
This topic specifically?
Mm.
No, so this wouldn't be something you could do in the first year, but if someone carried on with political theory into their second year, then this is a topic that you could end up encountering. So students who study politics, so either PP or history and politics, do some political theory in their first year, but this happens to not be one of the topics.
Brilliant, thank you. Any other questions? Brilliant, thank you. Let me get it up. So we've been asked, are there any books which are good for getting into this? Yes.
Well, so it depends which side of the case you want to some degree. So the book that's kind of the big book that argues against exemptions for both religion and culture more broadly is a book by a guy called Brian Barry called Culture and Equality. I think that's what his book's called, where it's a liberal egalitarian critique of multiculturalism. So he argues basically that we should have one law for everyone without exception, and he talks about cases involving both culture and religion. In terms of arguments, people who favour exemptions, it's interesting actually. Lots of the debate on this topic is more in kind of journal articles rather than books. But one really good thing is a book by Martha Nussbaum called Freedom of Conscience. Sorry. So there's a book, Martha Nussbaum, who's a very big deal political philosopher. She has a book called Freedom of Conscience, where she talks about exemptions and defends exemptions and makes various arguments similar to the ones that I've made.
Brilliant. I've noted those down. So in your sort of post-event email, I'll include those as well if anybody's interested. Thank you for your question. Do we have any more questions?
I was wondering if there were any like topics you could study in the politics course that you can't in history and politics combined course.
No, so not on the politics side. So yeah, the politics offering is the same for both history and politics and PPE. The one kind of no, I was going to caveat that, but there is no caveat to that. Yeah, so it's so in fact the first year for history and politics and PPE is compulsory, the politics, and it's the same on both sides. And then beyond that, it's the same set of papers available, but you get lots of choice. So people end up doing lots of different things, and some people who do history and politics prefer politics papers that have a more historical bent for obvious reasons, and so end up doing more of those, but the choice is the same.
Brilliant, thank you. Any further questions? If any of you would like to ask a current student about what it's like to study politics, then you can have a look on our college website, and when you go on the college website there'll be a little pop-up box that says chat to students. If you go on there, we've got quite a few history and politics students, and I think we've got maybe one PPEist on there, and you can drop them a message as well if you'd like to ask a sort of student perspective. Is there anything else before we round up? Any final questions?
I should correct, Martha Nussbaum's book is called Liberty of Conscience, not Freedom of Conscience.
Right. Cool. I'll look them up anyway, so I
check that. Yeah, remember the right names.
It'll be a spelling thing. So yeah, brilliant. I'll include them. Okay, well, I think we'll round up there. Thank you so much for your questions, everybody, and for coming along today. And a huge thank you to you, Paul. That was really, really interesting and really valuable. So thank you so much. And yeah, you'll be receiving an email from us with an evaluation form, which would be super helpful if you'd fill in for us, and some extra information about where you can find more information. So thank you very much.